right, guys. Well, good morning, everybody. How are you? All right, excellent. Nice to have you here. Nice to have. Thank you for having me here as well. Today, what we're going to do is a little bit of an in-service, so to speak, update you on the new power of attorney statute that's coming or has come down in Florida. Something that I think you should all be aware of in your interactions with your older clients. Also, in addition to that, we're going to deal with any Medicaid questions that you might have, anything that you want to pick my brain on that particular issue. So, very good. Everybody cool? How often do you run into in your case, in your situation, do you run into powers of attorney? Are you? Yes? Quite often, right? Now, are you dealing with the power of attorney as in like the son or the daughter type situation, and they're making, right?
It's usually family, yeah.
Okay, usually family. Power of attorney, just briefly, so everybody knows that we're on the same page, is a grant of authority in somebody else to be you, okay? To be you in all kinds and all manners of different ways. Those ways are dependent upon what the document actually says. In Florida, powers of attorney are strictly construed. And what that means is if it doesn't say you can do it in the document, you can't do it. Broad language that says you can do anything that I could do if I was otherwise able to do it, kind of this broad sweeping language which we would think would cover everything, doesn't mean what it says. Strictly construed, meaning if it does, the words are not there saying you can do the thing, you cannot, or that person cannot do the thing on behalf of that person. Okay. The law changed in Florida on October 1st, 2011. The new statute for powers of attorney went into effect at that point in time. That means that the new powers of attorney have to comply with the rules and regulations and requirements of this statute for everything done after October 1st, 2011. It's November 3rd today, I think. Yeah. So this is relevant to everybody. What I need to tell you about, though, is that any documents done before October 1st, 2011 are still valid. Okay? So just because they changed the law on us doesn't mean that your old documents are not any good. Okay. What we're going to see, though, is over time as these new documents become more and more prevalent, banks and real estate companies and insurance companies, for example, are going to become more and more familiar with seeing this new format. And when they run up against an old format, I think the tendency is going to be to say, no, we can't use that because that's not on the new form. Now, that's wrong. Okay, I want to make sure you understand that that's wrong. But I think that's going to be kind of the tendency that we'll see, that they're going to be reverting back to what they know and what they've been seeing. It's so new yet. It's only been a month out that most people even haven't seen the new forms yet. So, but coming down the road, expect to see that. Back to strictly construed. Strictly construed means if it isn't there, you can't do it. Believe it or not, about 80% of the power of attorney documents that I review in my office are actually done wrong. 80%. That's 8 out of 10. That's a lot. All right, that's a very significant percentage. Now, why are they done wrong? Who did them wrong? Are they wrong because they got the form off the internet, or they copied somebody else's form and put their name on it? All right, there's a multitude of ways that they could have gotten that document correct, including going to a lawyer and having the lawyer draft it for them. Even if it's done by a lawyer, 80% are still done wrong. And the reason for that is because they fail to have 5 very important components that are missing. And now any one of these 5 things, in my opinion, makes the document fail. What those 5 things are in no particular order, I'm going to go over with you right now. The first thing is the power to create trusts. Specifically, your cell phone going off during my presentation. Okay?
She's the boss, though, you know. Gotta give her a little leeway there.
Which is okay, not a problem. The first thing is the ability to create trusts. Wow, why is that important? Well, you all deal with Medicaid on a regular basis. And dealing with Medicaid on a regular basis, you are going to run in the issue of income qualification. In other words, in order to be eligible for Medicaid, the client has to be eligible under the income limits set out in Florida. Those limits are $2,022 of gross income per month. If your client has more than $2,022 of gross income per month, can't qualify for Medicaid, unless they put in place something called an income trust. Now, you all know this, all right? I'm just going to make sure we lay the groundwork, because of that power of attorney that the son has does not say he has the authority to create an income trust. He cannot. And if he cannot create the income trust, what happens? Can't qualify for Medicaid benefits, can't go on the diversion program. He's stuck, you're stuck, we're all stuck. Why? Because the stupid power of attorney, those 5 or 6 pieces of paper, don't have the right language in it. And this is a bad problem. Okay. Now, there are ways around this problem. As with any problem, there's obviously solutions. One of my favorite solutions is to do the power of attorney first, correctly, which means include the provision that has the language that says you can do a trust, and specifically an income trust. Gets a little tricky here on trusts, because some powers of attorney will use a modifier, an adjective, that qualifies what kind of trust the person can create. So instead of it just saying, my power of attorney can create trusts on my behalf, the power of attorney says, my attorney, in fact, my backup person, my agent, can create revocable trusts. So you see the words trust in there, can create trusts, but there's a modifier limiting the type of trust they can create. What kind of trusts? In that case, revocable. What kind of trust is an income trust? Irrevocable. So you see it can get a little tricky there? I mean, so yeah, you're looking through the document. Oh yeah, they can create trusts here. I'd say they can create revocable trusts. And your brain, maybe not understanding the distinction between irrevocable and revocable, just thinks we're in good shape. But nope, because they've specifically limited the type of trust that the person can create by that modifier, by that word revocable. So you got to be cognizant of that issue as well. If it just says can create trusts, thumbs up, we're good. If it says can create irrevocable trusts, thumbs up, we're good. If it says that person can create an income trust, double thumbs up. Follow me? So that's the first thing that I see missing in most of the power of attorneys that I review, is that ability to create trusts, which in our world, when trying to qualify our clients for Medicaid benefits, can be almost fatal. How do you work around this situation? Pretty much the only way that we can work around it is going through a guardianship process to appoint the court to come in, step in, fill the shoes of that individual, and then execute that income trust on their behalf. Well, that's an involved process that can take several months. So we want to make sure it can be shortened perhaps if we go in on an emergency basis, but it's an added expense and it's an added hassle. So, okay. Now, let me get my cell phone, because this is one of those things, and turn mine off. So there we go, perfect. Second thing, second omission. Oh, by the way, parenthetically, just if you have a power of attorney that doesn't say the right thing, and you have a spouse in the picture, they can sign the income trust on behalf of the individual without the necessity of having the explicit power in the power of attorney. All right. So that's a case that I want to make sure that that's a case that you may run into a lot of times. You have a spouse in the picture. He or she may be the power of attorney. I don't want you to review that document and say, oh, geez, you can't do this income trust. I want to make sure you understand that the spouse is an authorized person under the statutes to sign the income trust on behalf of their husband or their wife, okay, regardless of what their power of attorney says. All right. Second thing I see missing, anybody ever heard of IRAs, individual retirement accounts, tax qualified plans? These are very particular assets under Florida law, and under Florida Medicaid law specifically, under federal law as well, because of their tax nature. You've never paid taxes on that money that's sitting in the IRA. And the federal government and the state, they want to make sure that you do pay taxes on it. So there's all these particular rules about bringing that money out of the IRA. Okay? And since there's all these particular rules about moving the IRA, who's the owner of the IRA, when and how you can make distributions from the IRA, banks have a tendency to play with those documents, those accounts, differently than they would a regular bank account. Why is that important to you guys? Because through the process of qualifying for Medicaid benefits, the assets of the individual are going to be looked at to determine whether or not they qualify. And the IRA initially is going to be counted as an asset against them for purposes of determining eligibility. And Dale, is that your phone making that noise?
No, it's
That's
not.
the phone,
It's
yeah.
not.
Okay,
Yes,
fine.
we are.
Okay. Because if it was your phone, I was going to chastise you too.
Yeah, what do you think?
I know. Chastise, not yell. Chastise. Okay, so back to this IRA thing. They're special. All right, and since they're special, the banks treat them specially. And in order for your agent, the person that you're working with, the son or the daughter, or even the wife in this situation, that wants to go down and modify that account so that we can qualify the person for Medicaid benefits, they show up with the power of attorney that does not have IRA language in it. What does the bank say? No, we're sorry. We're not going to let you do what you want to do with that. We're not going to let you move it. We're not going to let you change the distributions of it. We're not going to let you change the beneficiary of it because it doesn't say on that piece of paper that you can. Strictly construed, if it doesn't say you can do it, you can't do it. And since the banks are very persnickety about this particular issue, because of the nature of the IRA, you're going to get a lot of pushback on that. And what that means is that can delay eligibility for Medicaid benefits, if not eliminate until you go back to guardianship court to get somebody appointed to be that person. All of this can be eliminated by having language in the document that says IRAs. Obviously, if you don't have an IRA in your situation, if your client does not have an individual retirement account, the fact that that language isn't in the power of attorney is kind of moot, isn't it? It doesn't matter. Just like on the income trust situation, if that person isn't over income, the fact that the language in the document doesn't say that they can or they can or cannot do an income trust is irrelevant as well. Third thing. Third omission, big omission, the ability to make gifts. Making gifts, usually counterproductive when trying to qualify for Medicaid benefits because they penalize you for making gifts. However, there are circumstances where we would want that person to be able to make a gift or move assets in one way or another. A lot of times when it comes to realigning the assets for Medicaid purposes in a husband and wife situation. When we have a husband and wife situation and they own things together, if the wife is going on to Medicaid, we want to realign the assets over into the healthy spouse's name so as to preserve and protect them and also make sure that if he dies first that they will go according to his will and estate plan, which we have to change obviously, but we need this segregation of moving everything basically into the healthy person's name. If that person can't make a gift, or then they can't make a gift to move that stuff. Part of this omission as well, not only do we need the power to make gifts, but we also need the power to make gifts to the named attorney in fact. That's an important component to this ability to make gifts, to the named attorney in fact. Power of attorney law is based upon agency and principle law, agent and principle. This type of law or body of law says is that an agent owes certain specific duties to the principal. These duties include not to self-deal, not to self-enrich yourself with the principal's assets. So if you take, let's say you are a power of attorney for mom, and you take mom's bank account and you give it to yourself and you put it into your name, that's enriching yourself under this concept. And under the power of attorney, under this agency and principle, that's self-enrichment, and that's a breach of your fiduciary duty that you owe to the principal. That's a big deal. So we want to make sure that you can do that in this situation, especially in a husband and wife case, because it brings us up to the fourth thing that we need to look at, and these things tie together, is the ability to convey real property, specifically the homestead of the individual. Florida law, again, says the home is a sacred asset. It has certain protections. It's not counted for purposes of determining eligibility for Medicaid. If it goes, when you die, it goes to your kids and your wife or your husband without any creditor's claims sticking to it. There's limitations on who you can give it to when you die, all kinds of stuff regarding your home. It's very much a sacred and very particular piece of real property in Florida. Because it has those particular things associated with it, in order for that home to be moved, conveyed, or changed title on, you need to have specific language in the document that says can convey the homestead. So you're looking for the magic word homestead there. If that magic word homestead isn't in there, in my opinion, it's a flawed document. You should have the ability to convey, change ownership and waive any homestead rights in that property. Why is this important? Let's go back to a husband and wife situation in a Medicaid application case. Husband and wife own a house together, not counted as an asset, will not interfere with her ability to qualify for Medicaid benefits. But as process of realigning these assets over into the name of the healthier spouse, we want to make sure that he has the stuff so that if he dies, his stuff doesn't go back to his spouse and disqualify her from Medicaid benefits. The house, even though it would be go back to her, so to speak, or be hers if she kept it in her name as a joint owner, won't interfere with her eligibility for Medicaid benefits. Under Florida law, that house is going to go to her heirs when she dies, to her children, without Medicaid being able to put a claim or a lien against it. All well and good. The problem is when is that going to be? When is she going to pass? And how long do the kids have to wait around for that house to now become liquid so that they can sell it, move it, do something with it? Could be years. And during that period of time, somebody's got to pay the freight on the house. Insurance, taxes, maintenance, and all that stuff. So it's very much an important thing to be able to allow the agent to convey homestead property, as well as being able to convey that homestead property to themselves. Specific example, husband and wife own a house together. Husband is the power of attorney. Wife is going into care. We want to move the house to himself. She's incompetent. She cannot sign the deed. If he signs the deed on her behalf, he's making a gift to himself. So we need to have language that says he can do that. And we also want to have language that says that he can convey her homestead interest, which is kind of a separate interest in that house, to him as well, so as that can extinguish her rights in the home, so that when he dies, he can give that house to his kids. Do you follow me? And there's about a 50-50 chance that the healthy spouse will die first. So it's not, we always focused on the sicker of the two. They need the care. We're providing the care for them. We're getting them on Medicaid. It's all focus on this person and the sick person. And then all of a sudden, the healthy one up and dies on us. Car accident, stroke, who knows, whatever. Something we weren't expecting, and that can create problems. So we were up to number 4. Fifth thing on the list, as far as what I look for in determining the validity and how good a document is as far as a power of attorney is concerned, is whether or not there's a backup to the backup. The power of attorney, the named person, the agent, the person that's going to fill the shoes of the incapacitated person, that person needs a backup too. So we need a backup to your backup. So a power of attorney would say, I, Sean Scott, hereby appoint Tom Cox to be my attorney in fact, to be my agent, to represent me, to be me in all these particular ways, specifically enumerated within the document, and that's all I say. Okay, I become incapacitated. Tom takes over for me. But then Tom's on his way to work. Okay, he's out here on 49th Street trying to cross traffic, and bam. No more Tom. Okay. So who's taking care of my stuff? Who's taking care of managing my affairs? No backup to my backup. So in order to, I believe, I've done this many different ways in my career over the last 21 years, and I've finally settled on that it's a good idea to have a second person named in the power of attorney to fill the shoes of the first person named. Yes?
But you said the spouse can make sign paperwork and stuff like that. So
I said that the spouse can sign the income trust.
Oh, gotcha.
Not all paperwork.
Gotcha.
And which is interesting because a lot of times in a husband and wife situation, there is this assumption that, hey man, I'm married to you, then I can do everything that you can do and you can do everything that I can do because we're married. Mm-hmm. No way. Absolutely. It could be further from the truth. But we're lulled into that opinion because, well, we have a bunch of bank accounts together. My name's on it, and your name's on it, and either one of us can access it, and our scope doesn't go beyond that. But if I want to sell the house to her, I can convey my interest, but I can't convey yours unless I have a power of attorney that says I can. Do you follow me? Because it requires 2 people's signatures on that deed in order to convey our house to her. Similarly, stocks and bonds, for example, another asset that we may own together. My name or your name. If I die, you get it. If you die, I get it. Great. Well, the problem is the broker is going to require both of our signatures in order to sell that stock to somebody else or to sell it. Unless we hold it in something called street name, there's some flexibility there. But if we actually own the certificates for Apple or IBM or Home Depot, and it says my name or your name on it, we need both. The stock transfer company will need both of our signatures in order to convey that stock. If I have a power of attorney, I'm good to go. If I don't have a power of attorney for you, I can't move that stock unless I go off to the guardianship court to get somebody appointed to be you.
And
So,
what if it says or?
yeah,
This
is again, people are lulled into this sense because your understanding and most of your experience has been with the bank, and the bank account says my name or your name. Either one of us can go down and sell that or move that money out of that account. Our car, for example, has my name or your name. Either one of us, under the administrative rules in Florida, says that either one of us can sell that car. We don't need the other person's signature on it. So here we go. Or it means either one of us can do it. Then you run into the stock. Nope, different animal. Okay, you'd think it would mean the same thing. Not consistent. The house, especially not consistent. My name or your name still requires both of our signatures on that deed to convey it to a third party. So that's, again, this is some of the little things that you're going to get caught up in. You think that you know what you know, and then all of a sudden you don't know it. So that's, again, one of the reasons why I'm here today. All right. So everybody have any questions on those big five things? 5 omissions, 5 things that I run into when I review a document. I will grade the document in context for the client, and I'll give it an A, B, C, D, or an F, depending upon what that person's situation is. Last thing, it's not a big 5, but something that is kind of important to consider is the age of the document. There is no specific rule in Florida that says that an old power of attorney is invalid. There is no due date on powers of attorney when they stop being valid. However, powers of attorney are like loaves of bread. What's that mean? You leave them out on the counter long enough, what happens? It gets stale, right? Nobody wants to eat it. And powers of attorney are kind of like that as well. The older they are, the stinkier they get. And people don't want to deal with them.
It's like my family.
Like your family. The stinkier they get. But in this situation, that's why what I do is I can't tell you that the old document's invalid. And if we're dealing with somebody that's of marginal capacity, for example, they're coming on the diversion program, they have the beginning stages of Alzheimer's disease, they still know who they are, where they are, what they are, they can still identify their family members or their husband or their children, and they have a 10-year-old power of attorney, it's a pretty good idea for them to refresh that while we still can. Is it absolutely required under the law? No, the statute does not have a due date. But when you trundle down to the bank and want to use a 10-year-old power of attorney, bank's going to go, no. And now you're fighting that battle that we don't want to fight. And especially when we're dealing with a dementia situation, early stages, still have capacity. We know that person's going to lose the ability to create a power of attorney at some point in time in the future. Get it while we can. So is my advice to you guys. All right. Any other questions on on those big 5?
Is there any other way to have a power of attorney? Can it be approved without a lawyer?
Can you do one without a lawyer?
Mm-hmm.
I mean,
be legal
and still be legal
legitimate.
and legitimate. Absolutely. Okay. But there's a reason why I went to law school. And there's a reason why for the last 21 years I've honed my skills in dealing with this seemingly simple document. So yes, you can do it by yourself. But I don't recommend it. Okay. Because you may end up with a fundamentally flawed document. For the one very special reason, I don't know if you've ever heard of this expression, but you don't know what you don't know. So it looks perfectly fine to you. You got it off of LegalZoom.com. They should know what they're doing, you assume. Okay. Well, guess what? LegalZoom.com hasn't updated their documents to comply with Florida's October 1st change in the statute. So now you go down to Office Depot and you get one of these forms from Office Depot that says durable power of attorney on the top of it, and you fill it out. That form does not comport or comply with Florida's new statute. So it's going to be invalid because you didn't know what you didn't know. And that thing that you didn't know was that in order for a power of attorney to be valid after October 1st, 2011 in Florida, it has to have very specific provisions and language in it. And that's what I'm going to talk about to you next. So it's a good segue into the next thing. And what I call these the Super 7. We talked about the Big 5 before. Now we're going to talk about the Super 7. The Super 7, when the statute changed, and what the Super 7 are, and Dale, do we have those floating around somewhere? What color is that in their packets?
Not sure what color they are.
It ended up not?
I think they're white with highlighted colored print on them.
Okay, very good. Yeah, so yes, there you go. It is white. It's one of your white sheets. The Super 7. Florida changed its power of attorney statute, and it actually did. And when you read it and go through it, it's actually made it much better. All right, actually made it much better. In my opinion, made it much better. Made it more onerous in some ways, more difficult to get the document done correctly, but made it better. And we'll see when we go through the Super 7 how it picks up some of the Big 5. Super 7 specifically deal, and why I point this out, is it's a really easy way to see if your document is a new one or an old one. The new statute requires that in order for the attorney-in-fact, the agent, the backup person, to do certain things, that the principal, the guy or girl signing the document, must specifically initial these 7 things if they want these or one of these 7 things to be done, or all of them, or none of them, or some of them. Specifically must list them. So I'm just going to kind of just print. Sure. I don't have them all memorized exactly, so I want to get it right for you. I mean, generally I know what they are, and they're all on my form now because I put them there. But the first thing is to create an inter vivos trust, either irrevocable or revocable. Wow. Where have we talked about trust before? Income trust, right? Remember, it needed to have the document needed to have language in it that specifically said you could or couldn't do it? Well, Florida statutes now says if you want to be able to do an inter vivos trust, either irrevocable or revocable, you have to specifically initial next to that paragraph in order to be able to do that. So that's pretty cool. Just a second, I got to take you back to the old statute. One of the reasons why 80% of the documents are wrong, including the ones drafted by lawyers, is because the old power of attorney statute had a sample power of attorney contained within the statute. Literally, you could go to Chapter 709, type in that sample power of attorney, sign your name and have it notarized, 2 witnesses, do whatever, and you'd have a power of attorney. Okay? You don't need me. Just go to Chapter 70908 and fill out that power of attorney. The problem is that the sample power of attorney contained within the statutes is wrong. Because it doesn't have the Big 5. Okay? It's wrong. What happens? Every other lawyer that's out there, they go to the statutes, they type in that document, they put it in their word processor. When their client wants to have a document, they just fill in the blanks themselves, and they charge you for that power of attorney. Because if it's good enough for the Florida legislature, it should be good enough for you. That's wrong. Because you see, those lawyers don't know what they don't know either. And they don't know about the Big 5. Why do I know about the Big 5? Because I deal with incapacity on a daily basis. And I deal with Medicaid application on a daily basis, and having to access and really get in and manage and move that person's assets. And I'm stymied routinely because of the failure of the document to contain the 5 big things, the Big 5. One of the new things that I love about the new statute is they got rid of the sample document. All right? There is no sample document any longer, which means we're not going to have this tendency to repeat the mistake over and over and over again. So now you got to draft your own. Well, gee whiz, you got to be a lawyer again. You just can't rely upon the statute. You have to actually draft your own document. So as part of drafting the own document, you need to include these 7 things. Number 1, just to review, to create inter vivos trusts, either irrevocable or revocable. We saw that in the Big 5. One of the Big 5 omissions was the failure to include that language. The new statute says that if you want to give that power, you have to specifically enumerate and or initial, I should say, next to that power. All right, so in my form, I have that listed with a little line next to it that the client has to initial. Why did they require these initials? Well, the legislature, the attorneys, the banks, they all got together to work on the statute, and they said, well, these are pretty significant issues, these particular these Super 7. And we want to make sure that that person really knew what they were doing when they gave that power to their backup person. So these Super 7 are the things that they thought were most important to make sure that that person knew that they were giving that power to somebody else as well. Okay, second thing, to amend, revoke, or terminate a trust created by the grantor. Okay, good, it's pretty self-explanatory. This goes to changing the estate plan of the individual. You can think about, let's say you have 2 kids, neither one of them like each other. One is appointed the power of attorney. Mom in charge. Never seen that before, right? Mom has a nice substantial estate of a couple $100,000, and in her revocable trust, it says when she dies that she gives everything equally to her 2 kids. Well, nefarious son, not the good son, but the one appointed to be power of attorney, has the authority under the document to come in and change or amend the trust. Uh-oh. What does he do?
Give everything to him.
Gives everything to him, right. Okay. Well, so do you want to give him that authority to do that or not? Well, I want to make sure that you've thought about it and that you've actually initialed next to that line. Now, there's a lot of good reasons why you'd want to give that authority to the son. Okay? And there's some good reasons why you might not want to do it. The reason why the legislature put the Super 7 in place is they really wanted the clients to know about this. And they wanted to force them to initial it. And believe it or not, that's actually working. Because as we've rolled out and done these powers of attorney for our clients now, they are actually, say I got to initial this, they're actually looking at these things and it's generating questions to me about what these powers actually are. So interestingly enough, their intent and why they did this is actually coming to fruition, and the clients are now asking these very important questions. Well, why do I want to do that? Tell me more. Because before, what the client would do is you'd throw the power of attorney in front of them. They said, well, do I have to read this? And where do I sign? Done. Okay, they oftentimes never read it. You'd ask them to read it. Say you should read it. They say, I don't want to read it right now. I'll read it when I get home. Where do I sign? Okay. So the legislature wanted to make sure that they knew this. Now, I'm going to stop on the Super 7 for a second and take you to another part of the statute, another significant change in the statute. Before October 1st, 2011, the power of attorney was mainly focused on the powers that the person had. The powers, what they could do, what they couldn't do. The new statute contains a provision which requires the inclusion of the duties of the power of attorney as well. Powers and duties are 2 different things. The duties, for example, are, one of the big ones, is not to mess with the estate plan of the principal. So if mom said everything goes in equal shares to the 2 kids, and you as power of attorney come in and say, I'm just going to move it all to me, you've now breached that duty that you owe to the principal. And because you've breached that duty, you are now subject to suit, recovery, surcharge, to get the money back. Do you follow me? So that's one of the big new duties, is that you cannot change or substantially change the estate plan of the individual. The second interesting duty, so it's a minor point, but it's something that's really fresh and new that we had never seen before, and that is the duty to keep records. Under the old power of attorney statute, if you were acting as the agent, the attorney in fact, the backup person, and you were managing mom's account, and you were writing checks and all of that, there was no duty for you to keep accurate records of the disbursements and the income of the individual that you were managing. Now, would it be a good idea? Probably. If you have, a pain in the butt sister that's sitting on, that's riding you, saying, "Where's mom's money? I want to know. Probably be a good idea. I mean, yeah, it was a good idea, but in reality, though, you didn't have to do it. Under the new statute, the duty is specifically listed there that you must keep accurate records of the income and the disbursements on behalf of that individual.
How is the policing done on that?
Well, that's a great question. How is the policing done on that? Well, again, no. It's a practical answer. Okay.
A few people in my mind.
Right. Exactly. It's a practical answer. See, that duty now in my document is specifically listed and enumerated. So when you're reading through it, well, what is this thing? Oh, I have a duty. You now know you have that duty. First of all, okay. Who's policing that? Your pain in the butt sister's policing it. And that's why I bring her up. I mean, because she's the one that's kind of on top of you and saying what's going on. And if you blow that duty, if you're not keeping good records, that gives rise to surcharge and removal of you as the agent. Do you follow me? So that she can be in charge now. Do you follow me? So it's kind of self-policing in many ways. If you're the only child and you're the only person that's getting everything, and you're the power of attorney, do you follow me?
Her parents.
And your mom's in a nursing home with full-blown dementia. Okay, the hen house and the fox, they're all in the same place. Okay, is this a problem? Not really, though. I mean, most people. I will tell you that when I tell my clients when they come to see me, daughter and mom, for example, that if daughter wanted to steal your money, she wouldn't be sitting here. She would have done it. She doesn't need me to steal your money. The fact that she's sitting here in my office working with us to get the legal papers in place to do the right thing is an indication in my mind that she's doing the right thing. And that's why in 21 years, I think I've only had one power of attorney go bad. Okay.
Sit here.
Well, and I understand. Well, and it's a filter. It's a filter because again, when the clients, I realize that statistic is skewed, and it's skewed because if that son or daughter is sitting in my office, again, they're sitting in my office for a positive reason, not a negative reason.
It's only if they get caught.
There is that. Only if they get caught. But I generally have a good faith in my clients and the children that I deal with. They're there to do the right thing. And I believe that, and I see that repeated time and time again. So let's go back to, we've talked about duties. You got to have these specific duties enumerated in the power of attorney. It's a new thing that we didn't have to do before. Back to our Super 7. The third thing down there is to make a gift of any amount or kind, including a gift in excess of the annual gift exclusion, including a gift to the named attorney-in-fact. Have we seen this issue before? Remember when I was talking about the Big Five? I mean, this is actually really cool because for many years, I've been railing against the failure to include these 5 things. And look what they've done in the Super 7. They're picking them up. And I didn't have anything to do with it. So it's kind of nice that we see the power to make gifts. Power to make gifts, very important. A lot of times in the older documents, they would include some sort of limitation on the amount of gifts that could be made. And they would tie it to something called the annual gift exclusion, which most everybody in this world knows, and sometimes they get the numbers wrong. $10,000 per person per year, for example, is the most common thing. That's actually wrong. It's $13,000 per person per year. It has nothing to do with Medicaid. That $13,000 gift disqualifies you from Medicaid benefits. Don't care if you can do it for tax purposes, it still disqualifies you from Medicaid benefits. Regardless, a lot of the power of attorneys would limit the ability to make gifts to some sort of standard. Can't make any more gifts than the annual gift exclusion, for example. I don't want to be limited in the amount of gifts I can make. Under the current federal tax law, you can give up to $5 million during your lifetime without having to pay any tax. How many of our clients have that quality problem? You follow me? So this whole issue of this annual gift exclusion and limiting it to that is kind of silly for 99.9% of our clients. So that's the third Super 7. Next one, to create or change rights of survivorship. Now you might see a trend here. All of this stuff is going back to who gets stuff when mom or dad dies. Rights of survivorship. I have a piece of property I own with rights of survivorship and my son. We own it together. If I die first, it automatically becomes his property. That's called a right of survivorship. Well, let's say my power of attorney daughter shows up and says, well, I don't think that's fair, she says to herself, that why should my brother get this property? So what I'm going to do is I'm going to change that deed or change that survivorship property some way, shape, or form so that it only goes to me. Another right of survivorship, a joint bank account, for example. If I die, my son's on that bank account. It's his money if I die. Well, again, my daughter, who has the power of attorney, says, that's not fair. I don't care what Dad wanted. I think that should be split between the two of us, so I'm going to go and change that account so it only reads Dad's name, which means when he dies, according to his will, I get half and my brother gets half. That seems much fairer to her. Not what I had intended. So you're seeing is that a lot of these Super 7 are trying to preserve and protect my estate plan and making sure that my stuff doesn't disappear and that my heir who was supposed to get it does get it. Next one. To create change beneficiary designation, including but not limited to bank accounts, individual retirement accounts, or similar tax-qualified account, annuities, and pension plans. To create or change a beneficiary designation. Back to who gets it when I die. Same idea, that same estate planning situation. By the way, that particular language that you're initialing there on the Super 7 is not good enough to manage the IRA. Because if you look what the language says, to create or change a beneficiary designation, that's all it's talking about. It doesn't say that you can change the distributions, make a distribution, move the asset, otherwise manage it. Okay, so you have to still have language within the document that will allow you to do that for the IRAs. Even though it's mentioning IRA here, remember, strictly construed, this provision only deals with changing the beneficiary. Next, to waive the grantor's right to be a beneficiary of a joint survivor annuity. Well, again, it's another way of holding property that says if I die, it's yours, and then after you die, it goes to somebody else. Well, I don't want it to be that way. For purposes of Medicaid planning, I don't want you to continue to have that right to have that annuity. Because you're my wife, you're in the nursing home. If I die, I don't want that annuity going to you and still hanging out there, affecting your eligibility for Medicaid benefits or whatever. So I want to change that ownership so it's just to me. Make sense? Mm-hmm. So that would be a really important power to have. Must be specifically initialized or initialed. Lastly, to disclaim property and powers of appointment. This is a little bit more esoteric, but let's say my uncle dies and he leaves me $1 million. All right. And if that $1 million comes to me, I'm going to take it and it's going to go into go by my estate plan, which is my will, and it's going to go someplace else. But I could also disclaim it and say I don't want it. And if I disclaim it, then it'll go to the alternate beneficiary in the will, which is my sister. My sister's my power of attorney. It's $500,000. Do I want to give her the authority to disclaim my interest in my uncle's $1 million estate? I don't know, but it's a topic for discussion. This is designed, again, to keep the money flowing the way it was supposed to flow and not allow the power of attorney, the backup person, to come in and mess with that. So you can see there's this big trend in the Super 7 of trying to preserve and protect the flow of assets according to what was in place and not disrupt that. Very good? Mm-hmm. All right. So that's effective October 1st, 2011. In summary, should have the big 5. Look at the Super 7, specifically initialing beside each of those. The power of attorney statute in October 1st, 2011 does not invalidate older documents. However, my recommendation to my clients now is when they come into the office, even if their document is only a year old, is to renew and redo their document under the current statute Why? Because moving forward, those are going to be documents that are going to be the ones that are more easily relied upon without having to have extra discussion with the bank about when the effective date of the new power of attorney statute was and trying to educate them. Better just to have a new document on the new form. Great. Any questions? Super. Super. Do you know more about powers of attorney now than when you sat down?
Absolutely.
Great. Excellent. Excellent. Well, it's been my pleasure to talk with you guys then today. And if you ever do have any questions or run across anything on powers of attorney that you want, give us a jingle, and we'll be happy to talk to you about that.